Hey, good evening, everyone. Well, for the purposes of time and for the purposes of convenience, I'd like to begin. So I would start with a countdown that I did lay down before I did schedule for this particular meeting. So I would start with a civil appeal on the recourse for the aggrieved party. So basically, appeals. I will begin with the aspect of appeals in its broad sense. So every decree, may be appealed from unless barred by some law. So however, an appeal does not automatically lie against every order. So Order 42, Rule 1 gives a list of orders, from which an appeal basically lies from as of right. Let me admit the people who are actually at the lobby first, and then I will proceed. Right. So if you want to appeal on an order that is not on the list, you understand that the same procedure rules do have appeals that do lie as of right. So if you want to appeal on an order that more or less is not on the list, you have to seek the leave of court. So what's the difference between a decree and an order? This is one of the questions that is normally asked during your oral exams. So a decree is always extracted from a judgment, whereas an order is always extracted from a ruling. So that's the discrepancy between the two. So when you have a judgment, you do extract a decree. And then orders themselves are actually gotten from rulings, and rulings may be premised on interim applications. I hope by now you do understand what an interim application is. So moving on to the application for appeal. So application for leave to appeal should be, made in the first instance to the court. So this is basically made the order itself that is being sought to be appealed against. So the pleadings that is always used is, CS within a period of time frame of 14 days from the date the order itself is made or orally in court at the time of making the order itself. So by now you do understand that the modes of approaching a court. I don't want to dwell on that because it doesn't form the basis, for the topic of discussion for today or for tonight rather. So an OS could either be a pleading or an application depending on the circumstances that it's normally used, whereas a CS is a full-time, application. So the CS, during appeal is always used, more or less used in the time frame for 14 days from the date upon which that order, which has been extracted from a ruling, and the ruling is founded or premised on an interim application. So it is all normally made, or rather, it could be made orally. You understand that we also have oral applications in court. So how do we file appeals? Appeals from the High Court, are filed by lodging an MOA. We call it a Memorandum of Appeal. When you're out here in practice, you wouldn't be using all these, complete terms. Okay, you have an OS to mean originating summons. You have a CS to mean chamber summons. You have an MOA to mean Memorandum of Appeal. You have an NTSC to mean the notice to show cause and what have you, etc., etc. So appeals from the High Court are filed by lodging an MOA or a Memorandum of Appeal, which is always set out, in the same manner as pleadings. Okay, so the grounds are set out in separate paragraphs and normally numbered consecutively. And again, normally or most of the times, the ground will indicate the reasons why you object to the decision of that particular code, depending on the hierarchical structure of the same code. So it's very consequential for you to make sure that, as an advocate, your grounds are set out comprehensively, because you will not be able to make submissions on any grounds not set out in your memorandum of appeal. So you would basically have to seek the leave of the court to submit on a new ground. and that the court has actually discretionary powers and can reject the appeal. Okay, so when you look at section 65 to 69, I guess, of the CPA, that's the Civil Procedure Act, enact the substantive law as regards the first appeals, while Order 42 of the CPR more or less lays down the procedure, relating to it. So, like I said, it is very important for you as an advocate to make sure that your grounds are set out comprehensively, okay? Because you will not be able to make submissions on any grounds not set out in your MOA. So you will have to seek the leave of court, to submit on a new ground. That's common sense, because supposedly you did include grounds on your application, the CS, and you don't rely on the same grounds, or you seek to rely on a ground upon which you didn't even include in the said, application, then you have to seek leave. So the court, has discretionary powers again and can reject the appeal. So the other issue is about the appeal itself now and the MOA. How do the two relate? So you have the expression appeal and the expression MOA, or the Memorandum of Appeal. So these two more or less denote two distinct things. So the appeal is a judicial examination, by the higher court of the decision of a lower court. Okay, that's the definition of appeal, what a layman would understand out here. So whereas, more or less the MOA, or the Memorandum of Appeal, contains the grounds on which the judicial examination is actually invited. Judicial examination is the scrutiny upon which the MOA itself is subjected to before being filed, okay, to the requisite court. So what are the requirements for valid appeal? So one, it must be in the form of a memorandum setting forth the grounds on which one objects to the particular decree. Okay, it must be again in the format and present as a record of appeal. The other thing you have to note is it must be signed by the appellant or their agent. Okay, so it also must be presented to the court or to such officer as appointed, by the court. So what you have to note and understand and comprehend is that the memorandum must be accompanied by a certified copy of the decree, and it must be accompanied by a certified copy of the judgment, unless the court dispenses with it. Okay, so where the appeal, is against the money decree, the appellant, must deposit the decretal amount or furnish, the security if required by the court. Well, how do you prepare now an MOA? So you have one, you have the pleadings. Okay, two, you have the issues forming part of your appeal. So these are normally substantial or substantive issues. Okay, and then you have the findings thereon, and then you also have the judgment and the decree, and also the record of proceedings in the court itself as well. These four basic things, the pleadings, the issues, the findings, the judgment, all these things form part of a memorandum of appeal. And then the other thing that I did denote on my breakdown or outline is when we say that the judge had and misdirected himself in issues raised before him, what do we exactly mean? Well, this basically means that, suppose the court finds you negligent and thus liable, you can appeal on the ground of damages, and say maybe for example that the judge or the judicial officer had in assigning what you call a quantum of damages. Back in your LLB, your undergraduate journey, you did learn about quantum of damages. Okay, so allow me to admit this person today. Right, so back to what I was saying. So when we do say that the judge had misdirected himself in issues raised before him, what we do mean is the example I've given, the court, say, a court in Bungoma finds you negligent, and that means you have to admit liability. So you can appeal on the ground of damages, and say, for instance, that perhaps the judge had in assigning the quantum of damages because maybe the damages are too punitive, and perhaps you as the defendant, really didn't perhaps deserve to, or warrant or compel the particular judicial officer or judge to give or assign such quantum of damages. So now this takes me back now to the presentation of the appeal. So the appeal must be presented with the prescribed time. So if the limitation period for filing an appeal has more or less lapsed or expired, you can apply for an extension of time to file the appeal itself. Okay, so this now takes me to the stay of execution. What is a stay of execution? Okay, what the rule of the thumb is the appeal does not automatically operate as a stay of execution. That is the rule of the thumb. All right. The same way on the other side of the criminal angle or the criminal litigation, which I will come to later, you have revision and you have appeal. If one chooses to seek revision, then automatically the right of appeal lapses. But again, this will depend on the intensity, complexity, and even the weight of the particular matter at hand, okay? So it's up to the person concerned, the accused in criminal litigation, and here you have the plaintiff or the appellant, depending on a case-to-case basis. So the appeal does not automatically operate as a stay of execution. So even if an appeal has been lodged and all parties served, the decree holder or a DH, okay, can proceed and apply for execution. So the court now appealed from, okay, the word is from, the court appealed from, made for more or less sufficient, cause or the stay of execution of such decree or even order. Like I said before, at this point, there's some things you should be having on your fingertips. What's a decree? What's an order? Order is, to ruling. What decree is to judgment. Simple as that. So if a stay of execution is granted, an application, may be made to the appellate court, right, to set aside, okay, order of stay from the court appeal from, if it actually seems just to the appellate court and person upon whom such order is made stands aggrieved. And you can refer this on Order 42, Rule 6, Sub Rule 1 of the CPR. Well, what are the requirements for order of stay? So the court is satisfied that substantial loss, may result to the applicant, and unless itself the order is made and that the application has been made without unreasonable delay. Okay, that's the first requirement. The second requirement, such security now, as the court orders, for the due performance of such decree or order as may ultimately be binding on him, has been, given by the applicant. Like I said, you could refer, to Order 42, Rule 6, 1, or just read the entire provision. Well, what are the powers of the appellate court on orders of stay? Well, however, the appellate court shall have, the power to stay executions upon such terms as it deems fit, even without a formal application having been made, pending the hearing of a formal application. Well, this means that an application for stay of execution may be made informally, immediately now following the delivery of judgment or ruling. You could actually make it to the floor of the court, or you could do this through the relevant application. Well, how is application for stay made? Actually, now this will answer the question I was trying to pose. Well, it is made by a way of notice of motion under Order 42, Rule 6. And also, if you look at Section 3A of the CPA, well, you have the we call it the double O, okay? the overriding objectives, like the things that the court, would have to be, you know, connected to, and this includes the issue of fairness, the issue of transparency, the issue of adequacy and timeliness of dispensing with our particular matter. So Section 3A, I know you've read about overriding objectives, and I'm not going to dwell on that for now. Well, when is appeal deemed to have been filed? Well, for the purposes, of a stay of execution, an appeal is deemed to have been filed as soon as the notice of appeal is filed. That's the bottom line. Well, again, under Order 42, Rule 13, Sub Rule 1 says, upon notice being delivered to parties within a period of 21 days after service of Memorandum of Appeal, it is now the duty of the appellant to cause the appeal, to be listed for direction through a CS application, right? So it is a CS that is used here. So what now are the documents required to be in the court record? In accordance with Order 42, Rule 13, Sub Rule 4 of the CPR. The first document is the MOA, of the Memorandum of Appeal. Second document is the pleadings that you have. Third document is the notes of the trial magistrate made at the hearing, if that is the first court of records. Okay. The other document is about the transcript of any official, shorthand, typist notes, electronic recording, or even what we call, I think, a palantypist notes. I don't know if you guys have been told about it. So you have the palantypist notes made at the hearing. And then the other document is about all affidavits. These could include the maps and other documents, so long as they are more or less connected to your matter. So this is whatsoever put in evidence before the magistrate. The other document is now the judgment, order, or decree appealed from, and where appropriate, the order, again, if any, giving leave to appeal, right? So provided that, one, you have a translation into English, shall be provided of any document not in that, particular language. And again, the judicial officer, or even the judge now, assume this is now the High Court onwards, so the judge may dispense with the production of any document or part of a document which is actually not relevant, other than those specified above, like I've mentioned. And specifically, you have what is this? You have the four things. I mean, is it 6 documents or something? Yeah. So the MOA, that is. You also have the other one was the pleadings, and then lastly you have the judgment. So all these 3 documents, these are the documents that are now specified, upon which now the judge, may dispense with the production of, any document or part of a document which is not relevant. So other than the Memorandum of Appeal, other than the judgment, and other than the pleadings, the judge could dispense with any document. Well, this takes me now to appearance. So Rule 13, thereof now provides for the, filing of written submissions where a party does not intend to appear at the hearing. So now how do courts, deal with appeals? When you look at Section 79 of the CPA, the court has power to summarily reject an appeal. Okay. So the court again has the opportunity in the first instance to do peruse the record of appeal, and if they find there are no sufficient grounds for interfering with the decree, the court may reject the appeal. Well, the way forward, or say the green light, is when it comes to appeal. If the court does not reject the appeal, then it proceeds to hearing. So the fact that the court has admitted your appeal does not mean you cannot get a default judgment. So if, more or less you do not appear, the court can dismiss the appeal for default, and it can also allow the appeal for default. Well, so just like a hearing, you are required, to appear at the hearing, but unlike now the High Court, you do not have to appear for hearing in person. Okay. Well, the procedure at the hearing of an appeal takes place in the following manner. So the procedure is that now the appellant, has the right to begin. Okay, the way we have on the other side of the criminal litigation, you have the prosecution. Okay, they have the right to begin. So allow me to admit this person who is of the lobby. All right, we can proceed. Well, the procedure of the hearing now of an appeal. The procedure is that the appellant on the civil appeal has the right to begin. On the criminal litigation side, you have the prosecution. So after hearing, the appellant now in support. Well, for the criminal, it could go either way, even the accused person, depending on how the case stands up after conviction. Well, after hearing, now the appellant in support of the appeal, if the court finds that the appeal has no substance, it can dismiss the appeal without calling the respondent. Okay. So that's one of the purposes of Section 3A of the CPA, those overriding objectives. The other issue is in addition, or rather, addition of parties or amendments can be done, in the Court of Appeal as well. So now the powers of the appellate court are as follows. Upon hearing now the appeal, the appellate court may exercise a number of powers, which include but are not limited to: one, it can opt to determine the case finally. Two, it can remand the case. Three, it can frame the issues and refer them for retrial. Right? Four, it can take additional evidence or require such evidence to be taken. Five, it can order a new trial. There is a difference between a retrial and a new trial. Okay, so those are the five key things, and this never misses in any CL exams. So I've said the powers of an appellate court include but are not limited to: one, it can opt to determine the case finally, to mean it will dispense with in its entirety and totality or in total. Two, it can remand the case. And three, it can frame the issues and refer them for retrial. Four, it can take additional evidence or require such evidence to be taken. Five, it can order for a new trial. So what do we mean when we say the appellate court could determine the case finally? Well, this power is exercised by the court where the evidence on the record is sufficient to enable the appellate court to pronounce judgment and to finally determine the case. That's what we mean. What do we mean by the power to remand a case? Well, here, in certain cases now, the record of appeal, right, may not be sufficient to enable the court to pronounce judgment or to enable it finally determine the appeal, in which case they will opt to remand the case. So this means to just, send back, to the court appealed from. Right? If it's the High Court exercising the supervisory jurisdiction, it sends back to the CM, right? If it's the Court of Appeal, it sends back to the High Court. So that's it. And then when can a court remand the case? So the court can remand a case in two instances. One, when the trial court disposed of the case on what we call a preliminary point, without hearing and recording the evidence on other issues. Two, where the appellate court disagrees with the trial court, right? So in such a case, the appellate court will set aside the judgment on the decree of the trial court and remand the case to the trial court for what you call a rehearing and determination, right? So the appellate court may also direct that, or rather what issues shall be tried in the case so remanded. So now by passing an order of remand, the appellate court directs the lower court to reopen and retry the case, right? So on remand now, the trial court will do what we call a readmission of the suit, or to readmit the suit under its original number in the Register of Civil Suits, and they will proceed to determine, to hear it as per the directions of the Court of Appeal. Well, what do we mean by the power of the appellate court to frame issues and refer them to trial? Well, the Court of Appeal may order that, certain issues be framed and that they be referred with certain directions to the lower court to be tried. So the Court of Appeal will exercise at all times, this particular power when the trial court did not frame issues properly or omitted, to try a certain issue or omitted, again, to determine a certain question of fact, which is essential to the right decision of the suit upon the merits. So the bottom line is the Court of Appeal doesn't deal with issues of facts before it when you come for appeal. It will deal with the issues of the law. But there's this instance where the trial court rather, may have failed, okay, to determine a certain question of fact. So that will be resuscitated by the Court of Appeal. And again, the Court of Appeal frames the issues, and sends them back to the lower court. That's the High Court. The High Court is a lower court and a High Court. I don't know if you do understand what I'm trying to say. So the Court of Appeal frames the issues and sends them back to the lower court. And after they are dealt with, they are sent back to the Court of Appeal. And this includes the questions of the fact that were omitted and also the certain issues that were also omitted. The other power of the appellate court when it comes to appeal is, to take additional evidence or require such evidence be taken. So what do we basically mean with this? So you have now the rule of the thumb is that no additional evidence is taken at the Court of Appeal unless a number of things happen. One, the lower court refused evidence which ought to have been admitted. Two, where the Court of Appeal needs certain documents or certain evidence to enable it to pronounce judgment. Three, for any other substantial cause. So those are the three instances when a Court of Appeal will accept additional evidence, right? So now how does the Court of Appeal take fresh evidence? Well, the Court of Appeal may take the additional evidence itself. That's one. Two, it may actually direct the original court to take the evidence. Three, it may direct the lower court to take the evidence for it. And then four, once the evidence is obtained, it is sent to the Court of Appeal and is used by the Court of Appeal to make its decision. And then last but not least, the Court of Appeal can order a new trial. So what do we mean by this? Of the appellate court, rather. So the power to order a new trial is intertwined with the power of review. So usually now this power arises where the entire trial was considered or misconceived fact or report, the wrong law, and therefore it will not be possible for the appellant court or the appellate court to justifiably reverse, vary, or even set aside that particular decision. That is to mean, it is the way the appellate court looks at the way the case was conducted. So that marks the end of my civil appeal presentation, discussion. I think I will move swiftly to the criminal litigation. Right? I will give you 30 seconds to breathe, and then we will pick it up from there at 9:01. Right. So we're back to criminal appeals, okay? And then the last part of my presentation will deal with the cross-cutting issues, right? So between all the civil appeal and the criminal litigations appeal. So appeals in criminal. So here, appeals, like I say, the definition doesn't vary that much, but it is an application to a higher court for a decision to be either reversed, reconsidered. And then it also relates to decisions of judicial and quasi-judicial bodies. I will list a few of quasi-judicial bodies later. Well, it may be again on matters of law as well as matters of fact. So depending on the hierarchical structure of the courts themselves, right? So what's the legal basis for appeals and criminal litigation? And one thing you should always be concerned about is, Article 50. That exclusively applies to criminal issues, right? So the legal basis of criminal appeals. When you look at Article 50, sub-article 2, paragraph Q of our Katiba, it says that every accused person has the right to a fair trial, which includes the right to, if convicted, to appeal to or apply for review by a higher court as prescribed by the law. Article 164 and 165 of our Katiba has also been emphatic on this, and it says that the jurisdiction of the Court of Appeal and High Court, respectively, will more or less apply on Article 50, sub-article 2, paragraph Q. And then Section 347 to 361, and again 379 of the CPC, Cap 75 of the laws of our country, has the legal basis of criminal appeals. The other thing is about the Appellate Jurisdiction Act, Cap 9. One thing I had forgotten to tell you in the civil appeal is when it comes to appeal in the Court of Appeal, they have an exclusive acts and rules, the Appellate Jurisdiction Act and its rules. That's exclusively for Court of Appeal. They don't more or less apply the procedure used in the CPR, right? So those rules and that particular act should be your companion for the next 3 weeks before you do your exams. So you also have the Court of Appeal rules, which I've talked about. So once you list all the legal bases in a question of appeal in an exam, you are good to go. At least the examiner knows your starting point or your foundation is strong to build the rest of the house. So there's a famous case here, and most of these cases right now should be on our fingertips. And aside from Arden versus Republic, and other landmark cases, there is a list I sent to your groups. Please go through that list one more time with all those cases and try to peruse which ones you know, which ones you don't know, and try to at least have an upper hand when it comes to or before you do your exams. So this is a case of Republic versus Jagani and another. This was a 2001 Kenya Law Reports page 590, right? So here, the court, held that a court on appeal will only interfere with the decision of the trial court where 3 or 4 things happen. 1, the sentence was actually imposed against the legal principles. And 2, the relevant factors were not considered. 3, irrelevant and or extraneous matters were considered, or the sentence is actually manifestly excessive in the circumstances. Okay? So appeals from subordinate courts. So when you look at section 347 of the CPC, a person convicted in a trial held by a subordinate court of first or second class may appeal to the High Court. And an appeal to the High Court may be on a matter of fact. For example, you have an identity of an accused person, as well as on a matter of law. For example, you have an appeal based on an equivocal plea. And you know very well for the ingredients in the case of Aiden versus Republic to suffice, the plea must be unequivocal, right? So an appeal could be based on an equivocal plea. And then you also have an appeal that is based on the ingredients of murder. You do understand, menstrual, and other ingredients that constitute a whole in the recipe of murder or the charge of murder. Section 348A of CPC says it gives rather the DPP the right to appeal where one, an accused person has been acquitted, or where an order refusing to admit a complaint or a formal charge or an order dismissing a charge has been made. So what you have to note, the above two has to be on a matter of law. Okay. So an appeal may be on conviction, that is on a plea of guilty, or perhaps sentence. Well, how does an appeal on a plea on guilty or plea of guilty rather looks like? Well, Section 348 of the CPC espouses on this. So no appeal shall be allowed in the case of an accused person who was plead guilty and has been convicted on that plea by a subordinate court, except as to the extent of legality of the sentence, right? However, there is some slight exception in this, and this is where the appeal touches on the plea. And I've talked about this and I've mentioned this, that the plea is actually equivocal and not unequivocal, as the case of Eden versus Republic, talks about. So the duties of the High Court. I will start with the case of Okeno versus Republic. This was a 1972 case, the East African Law Reports. So the High Court, as the first appellate court in this particular case, is entitled to more or less reconsider the evidence, evaluate the evidence, and draw conclusions in deciding whether the judgment of the trial court should be upheld. That's the case of Okeno versus Republic. It was a 1972 case. And then the first appellate court's duties were also laid down in a case that I know you've come across, the case of Kinyanjui versus Republic, a 2004 case, volume 2 of the Kenyan Law Reports, page 364. Well, it is, in this case, it is mandatory to look at the evidence before the magistrate afresh, re-evaluate the evidence, and re-examine the same and reach to its own independent conclusion whether or not to uphold the conviction. Okay, so the court now has to bear in mind that it did not have the opportunity to see the witnesses, testify. Thus, it is not expected at whatever given point, to make any findings as to the demeanor, comportment, and even the mien of the particular witnesses who are called upon to testify. Well, the other thing that was exposed in the case of Kinyanjui versus Republic is, aside from what I've said, is that the High Court itself is mandated to consider the grounds of appeal put forward by the appellant in reaching its judgment. And there is a case also, the case of Patrick and another versus Republic. So here, it stresses that the function of the court is not to scrutinize the evidence, to see if there was some evidence to support the lower court's decision. Okay, so the court must make its own findings and conclusions. It is not the court's mandate to scrutinize the evidence to see again if there was some evidence to support the lower court's decision. No, that's not the case. The court must make its own findings and conclusions. However, where the court overlooks and even fails to scrutinize the evidence, an appeal on this particular point may fail if it is shown that there was no substantial miscarriage of justice. And this was held in the case of Omusa versus Republic. Omusa is O-M-U-S-A. So Omusa versus Republic, it was a 2003 case, volume 1 of the Kenya Law Reports, and page 230. At your own convenient time, you could find more details about it. So what is the limitation of time when it comes to appeal in criminal matters? Well, when you look at section 349, it basically talks about this, that 349 of the CPC, okay? So it says that an appeal shall be lodged within a period of 14 days of the date of the order or sentence appealed against. So provided now the court may admit an appeal out of time, it is satisfied that the failure to enter the appeal has been caused by the inability of the appellant or even his attorney or his advocate to obtain a number of things. One, the judgment or order appealed from, or copy of the record, within a reasonable time frame after applying to the court. So those are the two things that will cause fatality when it comes to the limitation of time of appeal in criminal matters. So what is a petition of appeal? And I think I've sent a number of documents when it comes to drafting of these particular pleadings. And one of those documents contains the petition of appeal. Please just go through your groups. I've seen it there a couple of times. So petition of appeal, it is under section 350 of CPC. So here, an appeal shall be in form of a petition in writing, presented by the appellant or his advocate, accompanied by a copy of the judgment or order appealed against. So it shall be signed by the appellant or even his or her advocate, as the case may be. Okay? But bottom line is, an advocate is not supposed to give evidence. I hope you know that. To testify in court, orally or through a sworn affidavit. So when it also comes to a petition of appeal, it should contain particulars of the matters of fact or law appealed against. And again, in a petition of appeal, it should specify the address at which notice or documents shall be served. CLE, as mischievous as they are, they will give you a whole story. But be certain that all these things under section 350 of the CPC are in that particular story. So if you don't know what a petition of appeal contains, then it will be the end of the road for you in that particular case scenario given by CLA for you to find and identify what form of pleading is supposed to be drafted here. The appellant again shall not be permitted at the hearing of the appeal rely on a ground of appeal other than those set out in the petition of appeal, like what I said in the civil appeal. But there is an exception. Okay, so one, where one has applied for the record of proceedings within a period of 5 days of the judgment or order, and within the 14 days enters the appeal, but before receiving the copy of proceedings, you may amend the petition with notice to the High Court, Registrar, and the Director of Public Prosecutions within a period of 7 days of receipt of the proceedings. Please take note of these, timelines. They are very, very important, and that's what CLE uses to just confuse you. You have 14 days, you have 7 days. Kindly, and I will repeat, take judicial notice on all these timeframes, not only on appeals and criminal litigation, but even in other units. They're very, very important. When it comes to probate, those 6 months, upon confirmation of grant, objection, again, those timelines are very, very important and consequential as well. Well, the amendment that I've talked about here shall not be allowed now, where the advocate on record is the one who represented the accused in the subordinate court. So the appellant in prison under section 351. The appellant may present his petition again and the accompanying documents through the officer in charge of the prison, who shall forward it to the registrar of the High Court. Okay. Well, there's also what we call summary rejection or allowance of appeal, and you can check section 352 and 352A of the CPC. It talks about summary rejection of appeal and even allowance of appeal. And the notice of the time and place of hearing, you can check section 353 of the CPC. All right. The reason I've talked about the prisoner is because of the bail pending appeal. All right. So section 357. Let me admit this person who is at the lobby before we could proceed. And where they've gone to. Okay. So bail pending appeal. So section 357 of the CPC says that an application for bail pending appeal or suspension of execution of the sentence either apply to the subordinate court or even the High Court. So an appeal must, however, be lodged, before the application is made. And I would refer you to the case of Anand versus Republic. It was a 1952 case, volume 22 of the Kenya Law Reports, 338 page. So it was held to be irregular, to more or less release an appellant on bail before the appeal is actually lodged. So it is the existence of the appeal itself or the notice of the same that do invest the trial court with the jurisdiction to consider the bail application. So what now are the powers of the court? So the court may do a number of things when it comes to appeal. 1, dismiss the appeal. 2, reverse the finding and sentence and acquit or discharge the accused or order a wait trial by another court. And this normally applies on conviction. And then the court may also alter the finding, maintain the sentence, or with or without altering the sentence, reduce or increase the sentence. The court, with or without a reduction or increase, and with or without altering the finding, may alter the nature of the sentence. Okay? And then the court, in an appeal against the sentence, the court may increase or reduce it or even alter its nature. So appeals before the High Court, shall be heard before 2 judges, okay? Except where the Chief Justice directs it to be heard by 1 judge. And you can check section 359 of the CPC. So an appeal shall abate or cease upon death of the appellant. That's common sense. You can check section 360. The dead do not litigate. Again, appeals from the High Court. You can check the Article 164 of our Katiba talks about the jurisdiction of the Court of Appeal. And again, section 379 of the CPC. A person convicted by the High Court and sentenced to 1, death, 2, imprisonment for a term exceeding 12 months, 3, a fine exceeding 2,000 shillings, may appeal to the Court of Appeal against the conviction, okay, on grounds of law, fact, law and fact, or a hybrid of the two. That person also convicted by the High Court and sentenced to either death, the imprisonment, and a fine exceeding 2,000 shillings, with the leave of the Court of Appeal, he may or she may appeal against the sentence unless the sentence is one fixed by the law. That is to mean the sentence is actually no discretionary, for the trial court. And you can check the case of Godfrey Ochieng Songa versus Republic, a very famous case. It was a criminal appeal number 199 of 2006, and it basically captures what I've just talked about. Section 379, subsection 2 of the CPC, appeal against a conviction by the High Court with the leave of the Court of Appeal, or even upon a certificate of the trial judge that it is a fit case for appeal, where a number of things happen. 1, he or she is sentenced to a term of imprisonment of 12 months or less. 2, he or she is sentenced to a fine between 200 shillings and 2,000 shillings. And 3, a fine of 200 or less, where the appellate court or the trial judge is actually of the opinion that the case involves a question of law of great general or public importance. That is very, very critical. So appeal on a plea of guilty, it is allowed only, to the extent of what you call legality of the sentence. So bail pending appeal may actually be granted unless where the appellant himself or herself has been sentenced to death. There's no appeal. So section 379(4), there's no appeal, bail pending appeal, right? So section 379, subsection 4 of CPC. So this is basically the effect of Article 49, paragraph H of our Katiba. Again, this is a scholarly debate. If you ever want to do your master's in criminal law, you could make this your topic for your thesis. The relationship between Article 49H and Section 379, subsection 4 of the CPC. Okay, the form of the appeal. So Section 5 of the Appellate Jurisdiction Act, which I mentioned earlier, the Court of Appeal rules again. Rule 38 of the Court of Appeal rules, provides that where an appeal lies with the leave of the court, application for such leave shall be made in the manner laid down in Rules 42 and Rules 43 of the Court of Appeal rules. Rule 42 talks about that all applications, shall be by motion or notice of motion, which shall contain the grounds of the application in Form A of the first schedule and supported by an affidavit or affidavits pursuant to Rule 43 of the Court of Appeal rules. That's the form of the appeal. You could be asked to draft a form of appeal. It's not important. So what are the exceptions when it comes to the forms of appeal? One, where any other rule allows an informal application. Two, where an application is made in course of the hearing or in the course of the hearing, which actually may be made informally. And then three, you have where an application itself, is made by consent of the parties. What is a notice of appeal? So this is normally governed by Part 3 of the Appellate Jurisdiction rules. Allow me to admit this person who is at the lobby. All right, we could proceed as I come to winding up this. Well, I've said the notice of appeal is governed by Part 3 of the Appellate Jurisdiction rules, which apply only to appeals to the appellate court. So any person, who desires to appeal to the court shall give what we call a notice, and that notice is supposed to be in writing. Take note, please. So this notice, shall be lodged in what we call a sextuplicate. You know how many copies those are. So the notice of writing, shall be lodged in a sextuplicate with the registrar of the Superior Court at the place, where the decision against which it is actually desired to appeal was given, within a period again of 14 days. And I've told you to take judicial notice on these timelines, within a period of 14 days of the date of that particular decision. And the notice of appeal shall institute the appeal. You can refer to Rule 58 of the Court of Appeal rules. Well, every notice of appeal shall, one, state, shortly the nature of the acquittal, conviction, sentence, or finding against which it is desired to appeal, and two, it should contain the address at which any documents conducted with the appeal may be served, on the appellant. And you can check Rule 58, Sub-Rule 2 of the Court of Appeal rules. So the notice of appeal shall be in Form B. Remember, we have the Form A, form of appeal. This is notice of appeal. The other one is Form A. This is Form B. So the notice of appeal shall be in Form B of the first schedule. And you can check Rule 58, Sub-Rule 7 of the Court of Appeal rules. So soon after, receiving a notice of appeal, the registrar of the Superior Court shall prepare a record of appeal and cause it to be served upon the appellant, respondent, and registrar of the Court of Appeal. Okay, you can check Rule 61 and Rule 62 of the Court of Appeal rules. Rule 63 basically talks about that once the appellant is served with the record of appeal, he shall file the memorandum of appeal in quintuplicate within 14 days. So the memorandum of appeal shall set out concisely and under distinct heads numbered consecutively without any argument or narrative. It just states you will argue in court. The grounds of objection to the decision appealed against, specifying again in the case of a first appeal, the points of law or fact, and in the case of any other appeal, the points of law which are alleged to have been wrongly decided. Get this. You have the case of a first appeal and you have the case of a subsequent appeal. Right? The High Court may form an original jurisdiction for for appeal and even first appeal, depending if the matter came from the Chief Magistrate Court. Okay, so the High Court will be a case of first appeal, a court of first appeal, and at the same time, it may assume its original jurisdiction depending on the matter, because sometimes, the High Court has exclusive jurisdiction, original jurisdiction when it comes to certain matters. Right. So a memorandum of appeal shall be, substantially in the Form C. Again, get note or take note rather. You are Form A, you are Form B, you are Form C. So we are Form C here. Form C is the memorandum of appeal, which shall be, substantially in the Form C, which I've talked about in the first, schedule, and shall be signed by or on behalf of the appellant. And you can check Rule 63, Sub Rule 4 of the Court of Appeal rules. So if no memorandum of appeal is lodged within the prescribed time, the court may actually dismiss the appeal or may direct that it be set down for hearing. So if dismissed now, it actually may be restored if good cause is shown. Right? So second appeals. What are second appeals? And this is the last part of my criminal litigation appeals presentation. So second appeals now, here, a party now to an appeal from a subordinate court may appeal against a decision of the High Court in its appellate jurisdiction on a matter of law only. And the Court of Appeal shall note here an appeal, one, on a matter of fact. This is one thing that I think is now some chorus to you. So the Court of Appeal shall not entertain any appeal on a matter of fact unless that matter of fact was purposefully omitted by the trial court. So the Court of Appeal shall not hear an appeal on a matter of fact and severity of a sentence uh, is a matter of fact itself, okay? Or it may also fail to entertain an appeal against a sentence except where a sentence has actually been enhanced by the High Court unless the subordinate court had no power whatsoever under Section 7 of the CPC to pass the particular sentence. And you can check Section 361, subsection 1, paragraph A and B of the CPC, okay? Then lastly, now do note uh, the second appeals do not apply in cases where the High Court refuses, to admit an appeal out of time. And you can check Section 361, subsection 8 of this Criminal Procedure Code, Cap 75 of our laws for your further reading. And with that, ladies and gentlemen, this marks the end of my appeals in both criminal and civil. So my last part for today will be the cross-cutting issues. Again, I will give you 30 seconds to breathe in and exhale. Then we'll pick it up at 9:31 prompt. All right, so for cross-cutting issues in both criminal and civil litigation, I'll talk about the levels of appeal, the High Court, the Court of Appeal, the Supreme Court, and appeals from decisions of quasi-judicial bodies. Well, I would start with the source of appellate jurisdiction. Because again, Celia asked these questions, by the way. What are the sources of appellate jurisdiction? So the supreme law of the land constitution is one of them, and then you have statutes and other subsidiary legislation. Again, this is not inherent, so you have to know that. So the statute itself may actually grant appeal as of right, or with leave of the court appeal from it. I've talked about this during the civil discussion. So the levels, the levels, I'll talk about the magistrate court of first class, the high court, court of appeal, the Supreme Court. Yeah. Okay. So appeals now from the subordinate courts. So again, make the Magistrate Courts Act captain of our laws your companion, okay, for the next 3 weeks. Section 10 now of the Magistrate Courts Act says that for magistrate courts of third class, actually right now in the criminal litigation, the classes of the magistrate courts have been dealt away with, but either way, they are still in our statutes. They have not been repealed, especially the penal code. But there are some bills in both houses of parliament to repeal or to amend some provisions of the penal code. So from the magistrate court of third class on criminal matter to the resident magistrate court, which we do now have as the lowest court of the land. So this is actually by petition within 14 days from the magistrate court of third class to the resident magistrate court. So it is by petition, within a period of 14 days. And then section 11 of the magistrate court from the magistrate court of the third class on civil matter to the resident magistrate's court. Again, this is by petition within a period of 28 days. Please take note of these timelines. I would still insist. So the higher court may actually extend this particular period. Section 12 talks about the powers of the appellate court. Yeah, so that's this appeals to the subordinate courts. And then civil appeals now to the High Court. So when you check section 65, subsection 1 of the CPA, cap 21 of our laws, from original decree or more or less part of a decree on a question of law or fact. So from Qadhi's court, it is Chief Qadhi or 2 other Qadhis to sit as assessors. They are not defined or as judges or what have you. Perhaps I don't know why, but regardless, they're still judicial officers. So the chief Qadhi or 2 other Qadhis to sit as assessors. That is from the Qadhi's court. Appeal from the Qadhi's court rather. So the criminal appeal to the High Court. You can check this at section 347 of the CPC. So from a conviction, and it can be both on fact and law. Then section 348, it says that no appeal from a plea of guilty unless is on legality of sentence. Right? In Eden versus Republic. Section 349, of the CPC must be within 14 days. Section 350, the appeal must be in form of a petition. Section 359, the appeal must be heard by 2 judges. Again, like I told you before, unless the Honorable Chief Justice, the Honorable C.J. Comey, that directs, that it be heard by a single judge. So the hearing of criminal appeals. So section 353, okay, of the CPC. The court now gives notice to appellant and respondent of the advocates of the date and place of the hearing. They have to furnish copies of proceedings and even the grounds of appeal. Section 354 of the CPC talks about the counsel for both parties, advocate, then you have the respondent to address the court. Section 354, subsection 3 of the CPC talks about the court may actually dismiss the appeal, or reverse finding and sentence and acquit. Then it may order retrial or reduce or increase the sentence. Section 354, subsection 4 talks about if the appellant desires to, he or she is actually entitled to be present at the hearing of the appeal. That's it. And then the constitutional power of the High Court. I've talked about this. I'm just doing a recap. So Article 165, sub-article 3, paragraph C of our Katiba talks about the High Court, to hear appeals from decisions of tribunals. Okay. So the civil appeals again to the High Court still under the CPA, Cap 21, Section 79B of the CPA talks about summary dismissal of appeal. Section 79C of the CPA talks about what? Talks about appeals from subordinate courts to be heard by one judge unless again CJ otherwise directs. So appeals to Court of Appeal, how do they look like for both instances? I mean, criminal and civil. Well, the Court of Appeal rules of 2010, made under the Appellate Jurisdiction Act, Cap 9. Please download that act and those rules from Kenya law after this session. You'll thank me later. So here, the Court of Appeal established under Article 164 of our Katiba, it hears appeals from High Court and from any other tribunal as prescribed by statute or an act of Parliament. So the jurisdiction is under Section 3 of the Appellate Jurisdiction Act. Okay. So what are the types of appeals to the Court of Appeal? So one, you have an instance where the High Court was a trial court, and you have an instance where the High Court was actually the appellate court, right? So how do the two differ? Well, the criminal appeal to Court of Appeal by stating Section 361, subsection 1 of the CPC, it's on a matter of law. And then the severity of the sentence is actually a matter of fact. So if High Court enhanced sentence, then it is a matter of law if it's about legality of that particular sentence, right? So the appeal from the trial at High Court, so those two instances. So Section 379 again of the CPC. So let's say if you have been sentenced to death, I don't know if you do remember those three instances upon which appeal may be grounded. I talked about death, I talked about 12 months imprisonment, and I talked about you've been fined, 2,000 shillings and above. So if those three things are in place, the person may appeal on grounds of law or fact against conviction, or with the leave of the court against the sentence. So you can refer to Section 379 of the CPC. Okay. So the second instance was about appeal against acquittal. Remember that other one was on a trial in a court. So here it's under Section 379 subsection 5 of the CPC. So the Attorney General, or right now I think the DPP takes charge. So to within a month of acquittal, file now the DPP to within a month of acquittal file a certificate that that matter is of actually such exceptional public importance and that it is desirable in the public interest that the point shall be determined by the Court of Appeal, and the Court of Appeal itself shall review the case or such part of it as may be necessary and shall deliver what we call a declaratory judgment thereon. So the declaratory judgment is not to operate, to reverse an acquittal, but shall there be, or rather, it shall thereafter be binding upon all the courts, subordinate to the Court of Appeal, right? So we have other appeals, and these are appeals, to the Supreme Court, appeals from decisions of tribunals. So appeals to the Supreme Court most of the time, it has to be of general public importance. I think Article 50 or something. There's something to do with the general public importance. If a matter is supposed to be appealed from the Court of Appeal, and it's a criminal matter, it has to be one of great public importance. So you also have appeals from decisions of tribunals. And Supreme Court Act Cap 9A operationalized Article 163, sub-Article 9 of our Katiba. So leave is sought at first instance from Court of Appeal. That's the bottom line. So Section 15 of the Supreme Court Act talks about appeals to it are with the leave of the court itself. And Section 16 of the Supreme Court Act talks about the criterion. Mr. Mwaniki is always discreet, attentive, and stringent when it comes to the use of such terms. So you just don't say criteria. You talk of the criterion, okay? So the quasi-judicial bodies. So these are bodies from whose decisions appeals may lie to High Court, and we've seen this actually happening. Well, we have. I just list some of the tribunals. You have the Rent Tribunal, which you have the Business Premises Rent Tribunal, the BPRT. You have the Tax Appeals Tribunal. You have the National Environmental Tribunal. You have the Political Parties Tribunal. You have the Standards Tribunal. You have the Energy Tribunal. You have the Cooperatives Tribunal. You have the VAT Appeals Tribunal, which you'll perhaps see when I'll be discussing about taxes tomorrow. You have the Transport Licensing Tribunal. You have the Public Procurement Appeals Review Board, and you have the Legal Education Appeals Tribunal. That applies to you as a person undergoing the ATP program. It's very, very important. A lot of matters are being litigated there. So, I mean, appeals from these tribunals lie with the High Court. And sometimes one may seek to even bypass the statutory dispute resolution mechanisms that have been incorporated in these statutes to govern these tribunals and just go directly to the High Court, okay? But depending on how urgent your matter is and how willing are you to be through the litigious processes. So ladies and gentlemen, that has been my duty to take you through appeals, and I know I'm not going to do this again. So this is the not the first, but the umpteenth time. And for now, it's up to you to decide if you really want to pass the exams or not. So I've done my part with the limited time I have to create one for you, and just be part of your journey. So that has been the appeals presentation. Yeah, so let's see what tomorrow holds. If perhaps you have any more or less concern, you know where to find me. So I don't know if someone has a question here. Is this guitar? I guess I will pick a question and then we'll close. Yeah.
Just a clarity. I just wanted to know, where do we use this chamber summons? Just there, because I was lost there a bit. Just in 2 sentences or more. Thank you.
What time did you join?
When now you're mentioning the chamber summons, as I had on extension, I usually think it's a notice of motion. That's why I need a clarity there.
All right, let me take Claire's concern and then I will respond to you. It's clear.
Thank you. Okay, you mentioned, and also the rules provide that the petition of appeal should have an address for service. So I'm wondering, is that address for service, or rather, where do you put it, or does the drawn and filed by suffice as the address for service? Because the samples I've seen, they don't have like the specific address for service, but they do the drawn and filed by. Thank you.
Right. Well, the address for service is for well, could be that, but at the same time, it could also be the person to whom it is served, because it's an appeal and it has to be responded to, and the other party would rely on your pleadings or on your record of appeal to also prepare the case. So it could either go either way. So, Gitao, the rest of the 69 of you, could you answer him? Because I did mention clearly where do we use a CS in appeals? I mentioned it. If you are listening. So Gitao mentioned notice of motion. Is that the correct pleading? Hey, folks. Who could answer him? I did mention, come on.
I did hear you talk about the petition.
But there's something, I mentioned something to do, if you want to appeal as of right, what do you do? I mean, the things that don't fall under those matters that are appealed based on right on the civil procedure rules. And then also when it comes now to appeal itself, appeal in its natural sense now, what pleading do you use? Well, for leave, or just answer him. Who's that? Gesheru, yes.
Yes, you mentioned the chamber summons.
Why do we use chamber summons?
So basically, this I would want to believe is where let me put this other instance where maybe you want to make the appeal out of time, then there and then you move the court via the notice of motion. But then if you're appealing within the normal period of time, that is when then you move the court via chamber summons.
Well, anyone else? Fox. What did I say? Just talk.
I think you said it was the application where the appellant makes an application for the appeal to be listed for direction.
So what pleadings did I say would be used?
Chamber summons.
Come again. Did you talk about the normal application?
No. I was specifically responding to when chamber summons will be used. And I think you said that it will be used when the appellant is making an application for that appeal to be listed for directions.
Well, good trial. Anyone else before I respond and wrap it up? People, what did I say? Just well, what I mentioned is, I don't know if you could hear me. Well, I said there's a.
So sorry. I did, if I remember correctly, because now I'm trying now to correct what we have discussed. I would want to believe that you say that when you are appealing from the magistrate court to the high court, that is when you use the chamber summons.
Well, perhaps just to do this, his question is focused on where do we apply a CS. So what I mentioned is application, okay, for leave to appeal should actually be made in the first instance, to the court which made the order that is being sought to be appealed against. And this is where you use a CS. And I talked about a period of 14 days, from the date the order is made or orally in court at the time of making the order. Well, there's also the aspect of stay, okay, because a stay does not operate as an appeal, or rather the other way around. An appeal does not, operate as a stay. So for stay of execution, you have notice of motion. You have, well, you could make it orally before the court, or you could do it through notice of motion supporting affidavit, okay, and certificate of urgency, because it's a matter that you actually need to have it dispensed, as fast as it could. So the other requirements perhaps should form the basis now for your memorandum of appeal, and that include your pleadings. So that's it, and I guess that's what he was more or less looking for. Well, to understand this, I think you don't even need to cram. You just have to understand, how does this procedure work? It is express. That's why I've told you to get to download that particular Appellate Jurisdiction Act, the Court of Appeal rules, and have it with you. I'll also share some document on why would you use the chamber summons and not a notice of motion? Why would you use an OS and not a CS? Okay, and this includes even the question that has formed the basis of this particular discussion. Right. So, ladies and gentlemen, I really want to take any more time because of I have to attend now to work. All right. So,
Patricia, can I kindly text you and then we discuss it over? Because I have some questions, kidogo. Kindly, if you're not that busy. If you're that busy, like 5 minutes at most.
Well, I can promise that I'll respond immediately, but I will respond. But just text me your concerns, any more concerns that you have in anyone, and then I'll see where to pick it up. So, right. So that's it, and keep reading, keep believing in yourself, and keep the faith. So with that, I would beg to adjourn the session. Right.